In Ontario, self-induced intoxication can now serve as a defense for the accused in sexual assault and other violent crimes. Sexual assault victims are sharing their concern about their attackers abusing this law, but those in the legal field say there's little cause for concern.
What message this decision sends to women who are subjected to intoxicated violence. This sends a message to them that men can engage in risky behavior, they can get themselves extremely intoxicated, they can do incredibly harmful things, they can sexually assault people, and if they have been so intoxicated that they can prove that their conduct was involuntary, then in those cases they won't be held accountable.
The Ontario Court of Appeal has thrown out Section 33.1, a law previously banning an accused from using extreme intoxication as a defense. Ontario's top court says it tramples charter rights and is unconstitutional. The section was enacted in 1995 after a court ruling recognized it and sparked a public backlash.
I think the important takeaways, though, in the court emphasized that the fundamental principle of justice is that people shouldn't be convicted for offenses they didn't choose to do. This is dealing with a very rare defense. It's extreme intoxication akin to automatism. It's not mild intoxication. It's not moderate intoxication.
Automatism means the performance of an act or actions without the performer's awareness or conscious volition. Someone who successfully mounts an automatism defense will be found not criminally responsible by reason of a mental disorder. Talk to me exactly about what steps it would take to prove that somebody was in this state.
You would need some sort of evidence about the nature of the behavior. You would need expert medical evidence talking about the intoxicants that were ingested. Because of course we're talking about voluntary intoxication. So the intoxicants ingested, how the particular circumstance of the accused and why they might have had the effect they did.
According to Stats Canada, 63% of murdered women and girls are killed by someone under the influence of an intoxicating substance. The General Counsel for Women's Legal Education and Action Fund acknowledges how rare this defense is, but worries those who don't understand the law will get scared.
Women are incredibly reluctant to come forward and report about sexual violence and about having been victimized. And this is another case that is sending a message to women that will discourage them from coming forward to report.
How does this law risk the outcome of previous cases?
I really don't think it does. I think because it's such a rare defense and the evidentiary threshold being so high to raise it.
While the defense of extreme intoxication can stand in Ontario, that isn't the case for the rest of the country. However, it's expected if the Crown appeals this decision, then the Supreme Court of Canada will determine whether Section 33.1 is unconstitutional across the country. Maleeha Sheikh, City News.